Donald Trump has lost again at the appeals level, and Jean Carroll, the sexual assault victim of Donald Trump, has proven before two federal juries, is one step closer to getting her money from Donald Trump that she was awarded, the first $5 million that she was awarded based on a Second Circuit Court of Appeals ruling that just came out against Donald Trump. And Donald Trump has not only himself to thank for it, but the three lawyers who just lost are the three highest ranking lawyers that he's putting into his administration. They've already lost. They haven't even started their job. John Sauer for Solicitor General, Todd Blanche for Deputy Attorney General, and Emile Bove for Assistant to the Deputy Attorney General, all losers at the Second Circuit along with Donald Trump today. And justice is coming to Jean Carroll. I'll break it down for you. I'm Michael Popok. You're on the MeidasTouch Network and Legal AF. Let me unpack this because it's complicated. There were two cases involving Jean Carroll. One was brought after she claimed that she was, and now proven, that she was sexually assaulted in a department store dressing room across the street from Trump Tower back in 1996. She brought a case alleging that not only was she sexually assaulted, but that she was defamed by Donald Trump while he was in office. While that case was being tied up by immunity arguments by Donald Trump because he claimed, well, I was president, so I was allowed to defame her and deny that I ever sexually assaulted her in that dressing room. New York changed its laws to allow adult survivors of sex crimes and sexual assaults to bring, in a one-year window, to bring cases against the people that assaulted them. And so she brought a second case against Donald Trump, this time not just for the assault, but for the defamatory statements he made after he was president to avoid the immunity problem. That case we call Carroll 2. Carroll 2 was tried first. Just to be more confounding. It was tried first in front of a 9-person jury. And she won. She testified convincingly to that jury, 9-0 in her favor, that she was sexually assaulted. She said, as the court has reminded Donald Trump, she says that Donald Trump put his penis into her vagina against her will in that dressing room. That's in a footnote from this new order, but that the jury concluded that it was at least sexual assault that had happened there. And in addition, they gave her punitive damages and actual damages totaling $5 million. Now, during the trial that was presided over by Lewis Kaplan, a federal judge, he made some evidentiary rulings. Every trial judge makes evidentiary rulings about which witnesses or testimony can come in and which can be precluded. They serve a gatekeeping function in front of a jury in a jury trial. That's what judges do when the case is going to a jury trial. Now, Donald Trump claimed in his appeal that there were a number of errors, reversible errors, meaning he wants a new trial and to throw out the judgment that he claims Judge Kaplan committed while he was presiding over the case. Particularly, Donald Trump didn't like the fact that two witnesses testified, Natalia Stoyanovich and Jessica Leeds, who claimed that independently at different times, Donald Trump had sexually assaulted them, one on an airplane and one in a closet or in a bedroom of Mar-a-Lago while she was trying to do an interview. That was Stoyanovich. So you had that testimony. The Access Hollywood tape was brought into evidence and played for the jury, in which Donald Trump told Billy Bush of Access Hollywood fame on a hot mic moment when he didn't know he's being recorded, that he was allowed to grab women by their genitalia because he was a celebrity. All that came in under a rule of evidence called 415, which allows prior sexual misconduct to be presented to the jury to help prove that the thing that's in front of the jury actually happened. It's an exception to the rule that you're not allowed to bring in other evidence of propensity, something you did in the past or you made to prove this particular bad act. But Congress, in passing 415, because Congress sets up the rules of evidence and passes it, they made an exception. And they said, well, in sexual misconduct, if somebody's done it before, it's probably a pretty good indicator that he's going to do it again or has done it again. Let that evidence in. So you have the 415. The last balancing that a trial judge has to do about evidence, however it comes in, under Rule 415 or otherwise, is they have to do a balancing to determine if the probative value, the value of tending to prove or disprove a fact in the case, is outweighed by the prejudice to the defendant. And in this case, after balancing all of these things, Judge Kaplan said, no, this evidence its probative value is strong. The prejudicial impact, we're already here on an alleged sexual assault case, is low, and he let it in. Donald Trump didn't like that. So he didn't like the Access Hollywood tape, and he didn't like that the other two women were also testifying against him for assaults. He objected for different reasons about the women. He said, first of all, what she claims happened on Jessica Leeds claims happened on an airplane, he says was not a crime, that he was allowed to touch her breast and try to put his hand up her skirt, and that was not a crime. That was his best defense, by the way. And the second, I'm going to read to you from the brief, the order of the Second Circuit in a moment. But I'll tell you in sum, the three-judge panel who ruled unanimously 3-0 said, yeah, that was a crime when you did it. We had a crime on the books against unwanted touching on a plane, and so that's coming in. He had another argument as well about having certain evidence about Jean Carroll that was denied. You know, there's a lot of talk about a blue dress or a black dress coat that she said she kept because she was psychologically traumatized by the assault, and that she kept it in the back of her closet, and she claimed it may contain Donald Trump's DNA because she was wearing it that day. It was never tested. Donald Trump never submitted to a test, and so the judge precluded the dress, any reference to the dress and to the DNA. Well, Donald Trump says, no, I should have been able to cross-examine her about the dress. The judge below said, no, because you didn't allow the DNA to be sample to be provided. And the Second Circuit agreed with Judge Kaplan in rejecting Donald Trump's argument about the DNA and the dress and the allegations concerning it. Now, one of the things that we forget is that appellate courts are the courts of sort of last resort, and they get to rely on how the jury has found concerning the facts. And here's the facts, just to remind everybody who just got elected president. This is on page 5, 6, and 7 of the new order written by the panel. In 1996, Ms. Carroll encountered Mr. Trump at the Bergdorf Goodman department store in Manhattan. At the time, Ms. Carroll was an advice columnist for Elle magazine. Mr. Trump recognized Ms. Carroll and asked her to stay and help him pick out a gift for a girl, describing this as a funny New York scene and a wonderful prospect for a born advice columnist to give advice to Mr. Trump on buying a gift. Ms. Carroll said yes. After Ms. Carroll suggested that Trump purchase a handbag or a hat, he proposed lingerie instead, and they went to the 6th floor lingerie department at Bergdorf's. Mr. Trump selected a piece of lingerie and insisted that Ms. Carroll try it on. Ms. Carroll jokingly responded, "You put it on, it's your color." After some playful banter, Mr. Trump took Ms. Carroll's arm, motioned for her to go to the dressing room with him. Because Mr. Trump was being very light and pleasant and funny, she walked with him into the open dressing room. He immediately shut the door, shoved her against the wall so hard that her head banged against it. Miss Carroll, this is from the page 6 of the order. Miss Carroll pushed Trump back, but he thrusted her back against the wall, causing her to bang her head again. With his shoulder and whole weight of his body against her, Mr. Trump held her against the wall, kissed her, pulled down her tights, and stuck his fingers into her, pardon the expression, but it's from the order, her vagina, until Miss Carroll managed to get a knee up and push him off of her. She immediately exited the room. Now, there's also a footnote at the bottom of this order written by the 3-judge panel that says, Miss Carroll, footnote 1 on page 6, also testified that Mr. Trump inserted his penis into her vagina. The jury, however, found that she did not prove this part of her claim by a preponderance of the evidence, and that's the report of the 3-judge panel. She then told 2 of her friends, they were outcry witnesses, that's what we call them in the law, Miss Birnbach and Miss Martin, about the sexual assault at the time. The defamation is because Donald Trump, and this is on page 7 and 8 of the order, it's because Donald Trump made statements while he was still president of the United States, and then after he was president of the United States, about not knowing her. It was a shakedown. She's a con artist. It's a hoax. She's promoting a book. It never happened. I don't know her, and the like. Now, when he was cross-examined, because he didn't like the Access Hollywood tape coming in either, when he was cross-examined about the Access Hollywood tape and the statements that were made by Jean Carroll's lawyer, Robbie Kaplan, this is what he had to say about that. We want to share an important message from our sponsor, Americans United for Separation of Church and State. If you care about abortion rights, LGBTQ plus rights, rejecting school voucher schemes, and fighting censorship, then guess what? You care about the separation of church and state. For more than 75 years, Americans United has been on the front lines defending your freedom to live and believe as you choose, so long as you don't harm others. And that fundamental right is under attack like never before in our nation's history. We know what we're up against, and the next 4 years will mean managing the onslaught of attacks from Christian nationalists and right-wing extremists attempting to force us all to live by their narrow beliefs. Backed by $1 billion shadow network, this vocal minority is pushing their anti-democratic agenda everywhere. But here's the thing. You can make a difference by joining Americans United. They've been through this before, and they will never stop fighting to make sure all of us can be who we are, not who Christian nationalists want us to become. In a country divided, they are Americans United. Join in the fight. au.org/legalaf. That's au.org/legalaf. It's hard to believe he actually admitted it this way. So during the cross-examination where they played the audio for him, in which he said to Billy Bush, not knowing he was being recorded, he said, well, I can grab a woman by her, and then he used the P word, by her vagina, slang word, and kiss her because I'm a celebrity and I can get away with that. Well, Ms. Kaplan did some searing cross-examination of Donald Trump, and I had actually forgotten some of this from the trial, but here's what's been repeated on page 47 of the order. Question, this is Robbie Kaplan to Donald Trump, and you say again, this has become very famous in this video, I just start kissing them. That's Trump. It's like a magnet, just kiss. I don't even wait. And when you're a star, they let you do it. You can do anything. Grab them by the pussy. This is from the tape. You can do anything. That's what you said, correct? Miss Kaplan says to Mr. Trump after playing the clip, and Donald Trump says, well, historically, that's true with stars. See where his mind is going already? Doesn't deny that that's him on the audio, and says, that's true with stars. Question from Miss Kaplan, true with stars that they can grab women by the pussy? Answer, well, this is Trump. Well, that's what, if you look over the last million years, I guess that's been largely true. Not always, but largely true. Unfortunately, or fortunately. I just have to leave that there for a moment. Question, and you consider yourself to be a star? Answer, I think you can say that, yeah. Now, this is also infamously a deposition where at the end, when he left the deposition, Donald Trump and his group of lawyers, he told Robbie Kaplan that he would, now wait for this one, see you next Tuesday. Well, they had another deposition date scheduled, but there was no hearing scheduled for Tuesday. And so Robbie Kaplan was confused until somebody on her team told her that he just called her the C word and spelled it out for her with that phrase. Lovely. So the Second Circuit then goes on to affirm almost all of Judge Kaplan's decision-making when it came to which witnesses and evidence would come in and which witness and evidence would come out. Now, they criticized him slightly on a couple of items, but they always found that his instincts were right. He did not abuse his discretion as a trial judge, and that he got to the right place. They may not have agreed with every rationale that he used, but they felt that under the law, that any error that he may have made, small as it may have been, was harmless, therefore not reversible, therefore the judgment stands. Now let me answer the question that I know is coming up in the chat here. What happens to the other much larger judgment that she obtained against Donald Trump from a second jury that approaches $160 million? What about that one? That's the one that Donald Trump had to get a bonding company to bail him out to put up a bond secured by his trading account. That is still on appeal. However, this ruling by this three-judge panel is going to go a long way to having Donald Trump be a two-time loser with Jean Carroll. He is likely to lose the second appeal. Lewis Kaplan, same judge, presided over that case. That had to do with statements that were made while he was president and the application of the immunity defense and punitive damages being given out related to that and other statements. That I think he's going to lose as well. This will go a long way towards that. Right now, unless the United States Supreme Court takes up this appeal about allegations after he was president, which I don't see any reason why they would take up this particular appeal on these particular issues, this appeal is over. And if they don't take up that appeal, there's a cash bond that Donald Trump put up in cash for $5 million that's been running with interest that will be turned over to Jean Carroll and her lawyers, I would suspect within the next 90 days. The other appeal, of course, that panel, that 3-judge panel for the Second Circuit knows about the ruling here. It's public. I just read it to you. And they will take that into an account, I'm sure, in making their ruling against Donald Trump. So when he loses that, and the Supreme Court isn't interested in that either, then she'll get her $160 million, $170 million, which has been running with interest since over a year ago, almost a year and a half ago, with a bonding company backing up that payment so that Donald Trump has to ultimately pay it. So I would say sometime in 2025, Jean Carroll is going to get about $170 million through her lawyers to her for Donald Trump's misconduct and defamation. It's very similar to what happened with Rudy Giuliani, where he has a $148 million judgment against him by an entirely different jury down in the District of Columbia, as the two people holding that judgment, Ruby Freeman and Shay Moss, chase after Rudy Giuliani. He's already lost one apartment in New York. He's about to lose another condo in Florida, and his shirt off his back, his car, all of his watches, all of his money to pay this judgment. So large judgments do get enforced. Finally, there's another huge judgment we're waiting on. I'm sure we may even get it before the inauguration from the state court and the First Department Appellate Division State Court of Appeals about Donald Trump and his persistent fraud in the operation of his businesses, where he's got a $450 million judgment that's up before the First Department. It's likely to be cut down in size a bit, but that's another multi-$100 million judgment that Donald Trump ultimately is going to owe, and for which he also had to put up a bond. I think he has a $175 million bond posted against that judgment. I'll continue to follow it all. Where else? MeidasTouch Network and Legal AF. New show on Tuesdays, including this New Year's Eve Tuesday. Popok Live, 8 p.m. Eastern Time on this YouTube channel. And then you can pick me up on Legal AF, the new YouTube channel that I curate. We already have 375,000 subscribers in about 2 months' time. Well on our way to our goal of 500,000 by the first of the year. We're people-powered. We're Meidas Mighty and Legal AF power with no outside investors. We appreciate you. Until my next reporting, I'm Michael Popok. In collaboration with the MeidasTouch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.